welcome to Crime in Court. This is a Canton cover up series, Commonwealth versus Karen Reed, and we also talk about Aidan Turtleboy Carney, who we are going to be talking about today. And their cases are very intertwined, so I keep this as a series together because as things come up, I give you guys the latest. And as you can also see, this is going to be a voiceover only. I am not going to be on camera just because I'm not feeling the greatest. My hips are quite painful today. I don't know what's up. I'm having some achy pains. But anyways, so this is episode 139, Aiden's Comms and Exclusion from Sequestration. So we're going to go over some of the latest filings for the Karen Reed slash Turtle Boy case. So this is regarding Karen Reed Trial 2.0. However, he's now a part of the case because he's been made a witness by Hank Brennan and he's on the witness list. And he also, Hank has tried to obtain his communications. For some reason, another judge, Judge Sisitsky, has been the one who has been overhearing those arguments, and he allowed Hank Brennan's motion in part, but it was very specific and said that he was only allowing the prosecution to have communications between Aidan and Karen Reed, because that's what they've been asking for, are these communications, which they should have already because the Commonwealth has, and they've taken, their phones multiple times at this point from different subpoenas and trying to bring it in front of a grand jury who refused to indict them on conspiracy to commit witness intimidation. That's what he's trying to prove between the two of them. And she's not charged with it. So the only thing that he's using it for is consciousness of guilt. And so it's a real tricky, slippery slope there. So, anywho, Judge Sisitsky said you can have communications between Aiden and Karen, only communications that are talking about intimidating witnesses or, whatever, about witness intimidation only. So Aiden and Karen both swear there's nothing about witness intimidation between the two of them, so they're not going to have anything to turn over. That was one of the arguments in one of the hearings because Cosgrove, the attorney who is uh, prosecuting Aidan Carney, he came to court one day with a thumb drive of all these communications, but they happen to be communications between Aidan and Karen's attorneys. But that's not at all what was in the order, and the judge kind of admonished them and was like, no, that's not what I said they're going to get. So you need to take your thumb drive back and fix it. So, as far as I know, that may or may not be resolved. I'm not really sure. But at this point in time, Aiden filed a motion basically to keep his his communications under seal, not to be leaked. This was argued also in court in their hearing, where Tim Bradel argued that Kate Peter, who has Aiden has a harassment order against, or harassment prevention order against, and she's been stalking him like crazy and basically trying to do anything she can to ruin him. And she said as much in those words in numerous live streams and whatnot. So she apparently has been getting leaked information from the Commonwealth, perhaps, or from law enforcement, somebody, because she's leaking information on her social media platforms. They proved that she was getting information, and Judge Sisitsky found that it was concerning enough that he wrote this prevention order. So Aiden asked for the protective order, and then Judge Sisitsky said, okay, yeah, there's reason to believe that the Commonwealth or someone within the Commonwealth and law enforcement's uh field of people, somebody is leaking things to Kate Peter, his arch nemesis. So here is the order on intervener. So he is intervening in this case because it's Karen Reed's case. It's Commonwealth versus Karen Reed, but he's intervening. So he's an intervener, they call it, because he's not really a party. But because he was brought in because Hank is filing for his stuff, he now has to become an intervener, unfortunately. So it says order on intervener Aidan Carney's motion for protective order. Before the court is intervener Aidan Carney's motion for protective order regarding sharing of cell phone data after a hearing on March 28, 2025, and a review of the submissions related thereto. This motion is allowed in part. The intervener has raised significant concerns regarding confidentiality related to the Commonwealth's prosecution of Mr. Carney. So, right there, this judge is like the only judge that has looked at Aiden's case with I don't know, I don't know him well enough, and I can't determine if he's like really on the up and up or what, but this is like the first big win, I think, or one of the first big wins. Like, he's acknowledging there are significant concerns regarding confidentiality and what's going on. Specifically, his concerns over law enforcement's use and or dissemination of data obtained by search warrants and extracted by Mr. Carney's cell phones. The court deems interveners' concerns sufficient to warrant for further court action, however, only as it pertains to data that is being produced per the court's March 20th, 2025 order. So the March 20th order was basically turn this over, anything that has to do with witness intimidation between Aidan and Karen. And so then they had a hearing on the 28th and argued for this particular protective order. And only as it relates to the above caption matter. So it only relates to his first order and this case. The court acknowledges that other investigative materials or discovery beyond that covered by this order are already the subject of the court's prior order concerning counsel's obligations, and intervener Carney, I don't know why I said that weird. It's Carney, not pronounced Kearney, it's Carney. And intervener Carney has also moved for an identical protective order in the pending case in which he is a defendant. That motion is not currently before this court. With regard to the the data extracted from Mr. Carney's phones and produced per the court's March 20th order, the court orders 1. All agents of the Commonwealth, including but not limited to any members of law enforcement. So, all members of the Commonwealth, that includes prosecutors, and any law enforcement agency or agent or contractor thereof, shall maintain the confidentiality of the data and shall not share, publish, disseminate, or otherwise disclose the data or any information concerning the data to anyone other than counsel of record for the Commonwealth in this matter, or counsel of record for the defendant. So only counsel for the Commonwealth or the defendant can receive such data because it's being leaked, or there's a history of leaks. Number 2, this protective order shall take effect when entered and shall remain in effect unless terminated by entry of the court order. And 3, any person who violates this order shall be in contempt of court. That means you, Kate Peter, if you share any protected material, you will, well, not Norfolk County, but in any other county, she would go to jail. But she's protected for some reason by the Commonwealth. So ordered this 31st day of March. Yes, I'm late on getting it to you guys. I apologize, but there you have it. All right, so now we've got the interveners, alleged witness. So he's a possible witness, Aidan Carney, motion to be exempted from sequestration order. So this is a motion because Aidan has been named as a witness by the prosecution, most likely just to keep him out of the courtroom and to prevent him from reporting on this case. He and his lawyers have filed this motion to allow him to remain in the courtroom. He has, well, in the past, there have been other people who um, have had been witness, for instance, Gretchen Boss, and she was allowed to be in the courtroom every single day during the first trial, but she was also a witness on the list. So it makes you wonder why things aren't applied equally in the Commonwealth. So now comes Mr. Aidan Carney by and through his attorneys and respectfully requests that this honorable court exempt him from the court sequestration of witnesses order. In support of his motion, Aidan Carney states the following. Mr. Carney has been named as a prosecution witness in the above entitled action as detailed below. The Commonwealth has represented that it may call him as a rebuttal witness to establish Ms. Reed's purported consciousness of guilt. Number two, Mr. Carney is an independent credentialed journalist who has been issued a press pass through the media office of the Supreme Judicial Court. Journalism is his full-time job and his primary source of income. Since early 2023, Mr. Carney's reporting has almost exclusively focused on the Reed case. His coverage of the Reed case includes publishing articles, which to date numbers over 500, wow, live tweeting important case developments as they occur, and hosting an online stream in which he discusses and analyzes issues related to the Reed case. His streams often attract tens of thousands of viewers who watch Mr. Carney for case news, updates, and analysis. Number three, the Karen Reed case is a high-profile criminal case which, for more than 2 years, has been the subject of extensive local and national media attention. The case is a matter of great public concern, is substantial part due to Mr. Carney's reporting on the matter, which started in 2023, and his belief that Ms. Reed has been framed as part of the corrupt and or incompetent investigation by law enforcement, which has included the Norfolk County District Attorney's Office, the Massachusetts State Police, and collusion with assorted civilian witnesses. McAlberts. I'll just say it. Mr. Carney's reporting Mr. Carney's reporting played a prominent role in the creation of the Free Karen Reed movement, a nationwide and worldwide group of Reed supporters that has grown so large and is so vocal in their support of Ms. Reed's innocence that the court, balancing the First Amendment right of Ms. Reed's supporters to express their opinion on the case with Ms. Reed's right to a fair trial, created a buffer zone for their free speech prior to the first trial. Due to the immense public interest in this trial, which has substantially increased since the first trial, and the court's concern that jurors not be impacted by the Free Karen Reed supporters expressing their First Amendment right, the court has expanded the buffer zone for the second trial. But put simply, the public interest in this case is immense, and it is critical that the credentialed journalists be provided the opportunity to cover and report on the trial. Number four, in what appears to be the latest move as part of their ongoing plan to silence Mr. Carney by suppressing his critical coverage of this case, the Commonwealth seeks to exploit the sequestration order by naming him as a potential prosecution witness, which would subject him to the routine general sequestration order entered in the case, leading to his exclusion from the courtroom and prevent him from reporting on the case. In essence, the mere act of naming Mr. Carney as a potential prosecution witness would enable the Commonwealth to silence a journalist who is an influential supporter of Karen Reed and a leading critic and foe of the prosecution. So, I mean, that's a great point. He by putting him on the list, their main goal, and it seems their whether this is their goal or not, they are going to be silencing him if they put him on a sequestration order, if he's not excluded from sequestration. They're silencing him. They're taking away his income, his livelihood, his ability to obviously, report on the case, which that's the goal. They don't want him to. So, at least I think that is the ultimate goal of the Commonwealth. And he is an avid supporter of Reed and a vocal uh, a vocal critic of the prosecution and the law enforcement who are involved in this case. So, of course, they don't want him talking. And he's probably like one of the most knowledgeable people about the case. So, he's like the go to person. So, that's why, they really want to silence him. The Commonwealth's desire to entirely gag and sequester Mr. Carney such that he could not even observe the proceeding or discuss them in any manner will harm the public's right to information on an important matter of public concern. Since many people rely on his reporting for updates, that's a good point too. People are relying on him, and by silencing him, you are not allowing public access to the people like you should. Number 5, if Mr. Carney were subject to the sequestration order based on the mere possibility that he might be a prosecution rebuttal witness on the relatively minor issue discussed below, which may not even be admissible against Ms. Reed, it will literally prevent Mr. Carney from performing his chosen profession. It will prevent him from doing his job, cause him great economic harm, and unduly restrain his First Amendment right to provide the public with information on a matter of great public concern. There is a danger that excluding Mr. Carney from the courtroom and denying him the opportunity to cover the case cited as will covering the case as cited um, will cite a precedent. Sorry, there's errors here in his writing, and I'm trying to get through them. So there is a danger that excluding Mr. Carney from the courtroom and denying him the opportunity to cover the case will cite as precedent by unscrupulous prosecutors who, in future cases, place any vocal critic with a public platform on their witness list in order to silence them of their criticism of the government. So anyone who has any kind of criticism of the government, all you need to do just, put them on the witness list and then they can't talk or be in the courtroom while proceedings are taking place. That's not really what the witness list is for or the sequestration orders are for. Number 6, to the extent the court has any concerns with the impact or content of Mr. Carney's First Amendment right to report on this case during trial, the court's repeated admonition to jurors about their obligation to avoid any media coverage in this case, including online media, will assuage any concern that Mr. Carney's right to report on the trial may improperly influence the jury. Indeed, whether Mr. Carney is able to report on this case or not should not impact the court's well-founded concern that the jury not be exposed to any outside media influence, irrespective of whether that content tends to favor Ms. Reed or the Commonwealth. Number 7. So they're not supposed to be listening to media anyway. So what does it matter if Turtle Boy is able to report on it or not? Like, it doesn't matter to the Commonwealth. It shouldn't matter to the case. It's not prejudicing them at all. So shut up, Hank Brennan. Number 7, in considering the Commonwealth's motive for placing Mr. Carney on their witness list, thereby subjecting him to the sequestration order, The court should take note that this is not the first time Commonwealth lead counsel Brennan appears to have exploited a witness list by excluding or by including or trying to exclude journalists critical to his position on it for the purpose of suppressing their ability to report on the case rather than for a good faith reason to examine the journalist's purported witness. So this is not his first go around with this. In U.S. versus James Bulger, Whitey Bulger, the mob boss that Hank Brennan is associated with defending, this case is where he is another example of where he tried to do this with some journalists. So in the U.S. versus James Bulger, the defense team, which included Mr. Brennan, sought to exclude 3 journalists whose reporting was understandably critical of Whitey Bulger, a notorious and treacherous gangster and murderer, by naming them as potential witnesses against Bulger. How'd that work out for them? The court denied the defense's effort to exclude the reporters from the trial, finding little danger of fabrication, inaccuracy, or collusion. The court noted that the First Amendment interests of the journalists to report on a high-profile matter of great public concern outweighed the minuscule risk that if called as impeachment witnesses, their presence covering the case as journalists could shade their testimony. The court also questioned the defense's claim that testimony from any of the journalists would be admissible or necessary. So the journalists, there was no real reason to have them on the witness list, and same here for Aidan. Number 8. Here, the ostensible purpose for the Commonwealth's inclusion of Mr. Carney on their witness list is to keep him, quote, on ice as a possible rebuttal witness regarding Ms. Reed's purported consciousness of guilt based upon her alleged communications with Mr. Carney. Notably, the Commonwealth already has represented to the court that they do not intend to introduce any such evidence in their case in chief, and that they only intend to do so on the rebuttal case if the defense opens the door during cross-examination of witnesses the Commonwealth alleges were intimidated by Mr. Carney and Ms. Reed. At best, the purported evidence of Ms. Reed's consciousness of guilt and Mr. Carney's testimony in support of such claim is weak, speculative, and to the extent that it is even remotely admissible, its probative value almost certainly will be outweighed by its prejudicial impact. Thus, without regard to the merits of the Commonwealth's speculation about Mr. Carney's knowledge or ability to provide relevant evidence of Ms. Reed's purported consciousness of guilt, the likelihood of the admissibility of the evidence and or the Commonwealth's need for Mr. Carney's testimony at trial is virtually non-existent and is substantially outweighed by Mr. Carney's First Amendment right to report on the case and his right to earn a living. So there's really very little information they could glean from Carney's testimony, and they're saying that it would, even if they did try, it impedes his First Amendment right. Number 9, assuming, among other things, in argument, no, not among other things, assuming in argument, for argument's sake, arguendo, sorry, assuming for argument's sake that evidence of Ms. Reed's consciousness of guilt based upon her interactions with Mr. Carney is admissible, it is hard to fathom why the Commonwealth would deliberately draw attention to Mr. Carney's actions and his motivation for them by calling him as a witness without having any opportunity to speak to him in advance of his testimony. So why are you calling him if you've never even talked to him? It strains credulity that experienced prosecutors would willingly afford Mr. Carney the opportunity, on direct examination no less, to explain and then place in context the substance of his purported communications with Ms. Reed, where each evidence clearly would be harmful to the Commonwealth's case and almost certainly support the defense's position. Put simply, the likelihood that the Commonwealth will actually call Mr. Carney as a witness appears virtually non existent. Not only that, he will make you guys look like fools. I would love it if they called him. Call him. And I would love to hear his answers in response to some of Hank Brennan's ridiculous questions. It would be probably one of the most entertaining moments of the trial, if not, well, probably not the most. I mean, we're still looking forward to Jen McCabe, Proctor, Trooper Paul 2.0. This is gonna be a wild trial, but that would be wild if they did call Turtle Boy and he basically showed them up with all of his answers because that's what he would do. Number 10. It is clear that Mr. Carney's First Amendment rights as a journalist to continue his reporting on a matter of great public concern and his right to earn a living substantially outweigh the Commonwealth's dubious and transparent speculative assertion that he may be needed as a rebuttal witness. Mr. Carney respectfully brings this matter to the court's attention before jury selection begins on Tuesday, April 1st. So they did bring this uh, motion, I think, on the 1st. She still has not ruled on it yet, of course. Go figure. And this is unfortunately going to Judge Bev to rule on. So it's not going to go to Sisitsky. It's not going to get a fair ruling, if you ask me. And I would be shocked, but not shocked, if she doesn't allow him in the courtroom, if she sequesters him. Like, it would be wild and outrageous, but at the same time, totally on par with Bev. So, anyways. The public's First Amendment right of access to criminal trials extends to jury voir dire, so he should also be able to go into voir dire, which he has been able to do so far. He's been sitting in voir dire. There's not a whole lot that they can actually learn other than, like 45 people showed up today at today's session, morning session, and, you know, 38 of them said that they've heard of the case or something. Like that's what the extent of what he's reporting right now. And then all of the questioning is being done by the judge, not the attorneys of the possible jurors. So Judge Bev is basically picking them. She's doing the questioning. She's picking. I mean, I guess they still have their um, strikes to strike jurors, but at the same time, I don't think they're not being given the fair opportunity to actually really dive into some of these jurors. But anyways, so that is part of the First Amendment right is being able to sit in during jury voir dire. So he is allowed to do that at this moment. In these circumstances, enforcing a general sequestration order to exclude Mr. Carney, a credentialed journalist, from attending the trial and reporting on this case would violate the First Amendment. There is no question that he has a First Amendment right to attend this trial the trial of this case. To the extent that the Commonwealth has, in fact, sought to exclude Mr. Carney because he is a well known, vocal, and prominent critic of their case against Ms. Reed, the First Amendment does not permit or tolerate discrimination between members of the press in granting access to trials and other governmental proceedings, including where, as here, Mr. Carney's exclusion appears to be based upon disdain for the content of his reporting rather than his actual need as a witness. So you don't need him as a witness, you just don't want him to report on your case. Here's a footnote that says during the first trial, Detective Lieutenant Brian Tully of the Massachusetts State Police, an essential witness against Ms. Reed and Mr. Carney, acting as a messenger for prosecution witnesses, Gretchen Voss, blank, 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 something's redacted. Ms. Voss did, in fact, attend the first trial despite being on the Commonwealth's list. So that's what I was talking about. Gretchen Voss from the Boston Globe, I believe, or Boston Magazine. And she interviewed Karen. They have her notes now. They got even more of her notes now. And she was on the witness list in the first trial, and she was able to attend every day. A court may not selectively exclude news media from access to information otherwise made available for public inspection. Such a practice is unquestionably at odds with the First Amendment. Neither the court nor any branch of the government can be allowed to affect the content or tenor of the news by choreographing which organizations have access to relevant information. So the government can't control what the media is putting out. They do, but they're not supposed to. They do it all the time, but they're not supposed to. And that's what this is saying. And the government can't prevent Mr. Carney. They can't selectively say, Mr. Carney, you can't report on this because we don't like your reporting. A city could not allow one newspaper access to public records and not another. Exceptions to sequestration order are commonly granted. There is abundant precedent for exclusion from a sequestration order with respect to certain categories of witnesses, such as government case agents in criminal cases and expert witnesses in both civil and criminal cases. Given the unlikelihood that Mr. Carney will be called to testify and in view of the exceedingly narrow scope of any relevant testimony he might offer, the public interest in his being able to cover the proceedings far outweighs any conceivable interest in excluding him from the trial of this case. District courts have considerable discretion in fashioning sequestration orders. Indeed, the Commonwealth sought and obtained exemptions for District Attorney Morrissey and a victim advocate, that's Steve Nelson, in the case at the final pretrial conference, two witnesses who clearly favor the prosecution in this matter. So they have been exempted from the sequestration order. DA Michael Morrissey and his office's victim advocate, who is a witness in this case because of all of the nefarious things going on in the DA's office. So, and his communications with the witnesses. So he should be a witness, but they're exempt. So they can watch all of the other witnesses testify, which I don't think is fair. But if they're exempt, why shouldn't Turtle Boy be exempt? And finally, based upon their placement of Mr. Carney and their witness list and recent filings and proceedings held before this court and Judge Sisitsky, it is obvious that the Commonwealth A believes that Mr. Carney's testimony will incriminate, sorry. It is obvious that the Commonwealth A believes that Mr. Carney's testimony will incriminate both himself and Ms. Reed, and B knows that if Mr. Carney is called as a witness, he will be unable to report on this case. Got a footnote here that says, the irony of the Commonwealth's conduct is not lost upon us. In essence, the Commonwealth has placed Mr. Carney on the witness list for the purpose of silencing his criticism of them. With full knowledge, it will cause him economic and or emotional harm, which is a form of harassment akin to the witness intimidation charges that they have repeatedly charged with him. So they're harassing him and intimidating him by putting him on this list, is his point, which is ironic because that's what they're charging him with. As the court is aware, Mr. Carney presently is under indictment for several counts of alleged witness intimidation related to his interactions with some of the witnesses against Ms. Reed. In March 2024, a grand jury uh, declined to indict Mr. Carney and Ms. Reed for conspiring to commit witness intimidation, but on March 20th, 2025, Special ADA Cosgrove represented that this matter was still under investigation. So a grand jury declined to indict them, yet a year later, exactly a year later, Cosgrove is like, oh no, this is still under investigation and could result in the Commonwealth impaneling a second grand jury. What? Like how what is the limit of their power, if any? Like, can they just keep coming after you and after you and after you? It seems like that is the case in the Commonwealth. It seems like they will do whatever it takes to bring down their enemies. And their enemies might just be innocent, award winning journalists who have been reporting critically against them. So, this is so scary and concerning, guys. If you're not scared, you should be. Putting aside the issue of whether the Commonwealth may offer Ms. Reed's alleged uncharged bad acts, which are presently under investigation as evidence of her consciousness of guilt during the trial, as a matter to be addressed by Ms. Reed's legal team if appropriate, it is clear that Mr. Carney were examined under oath. If Mr. Carney were examined under oath as a prosecution witness, the Commonwealth would seek testimony from him which they deem incriminating to Ms. Reed and himself, which you can't do. You can't ask him to incriminate himself on the stand as related to his existing indictments and the alleged investigation cited by Mr. Cosgrove. So they want to call him on the stand to get him to what? Confess that he's doing some illegal witness intimidating when that's exactly what his charges are? You can't do that. So, yeah. There can be little doubt that the Commonwealth would then seek to use Mr. Carney's Reed trial testimony against him in the proceedings against him. So exactly, they would use anything he says in his trial. In these circumstances, as attorneys for Mr. Carney, we have no choice but to inform the court that if Mr. Carney were to be called, if he were to be called as a witness against Ms. Reed, due to the proposed subject matter of the testimony and the circumstances described above, Mr. Carney will assert his Fifth Amendment privilege and refuse to answer any questions. So, even if you call him as a witness, and if you put him on the witness list just to sequester him and you call him as a witness, he's not going to testify to crap. So, there you go. He doesn't need to be sequestered because he's not going to testify in this trial because it could incriminate him in his own trial. I don't know why Hank, uh, however many years long practicing attorney, doesn't get this. We know that he knows how to be a lawyer. We know he knows how to be a jackass of a lawyer, but a lawyer nonetheless. He knows that he should know these laws and things that, you can't go after somebody who might incriminate themselves in their own case, especially if you're not even offering them something in return. So they're not offering him something like, yeah, well, drop your charges if you testify against Karen. They're not even offering that. Or will lessen your charges or whatever. It's just a intimidating move. That's all it is. Intimidating and potentially, career not breaking, but career halting because you want to enable him from making money on this by reporting on this case. That's how he makes a living. This fact, without more, should exempt Mr. Carney without being subject to the court's order for sequestration of witnesses. For the foregoing reasons, the court should allow Mr. Carney to be exempted from the sequestration order. Wherefore, Mr. Carney respectfully requests that the court enter the foregoing orders and any such other relief as it deems meet and proper. And that's by Timothy Bradle and Mark Butterow. And as we know that we'll see with Bev, it's a coin toss. You could go heads or tails with her and still be wrong. Or right, just depending on the day. It's just luck because she's not consistent. And the way that she's been ruling lately, I feel like she's going to make Aidan be sequestered. But it would be absolutely, unbelievably wild if she did, especially for the fact that he will assert his Fifth Amendment privilege. And it is in writing right there telling you he will do so. So there's no point in calling him, What do you guys think? Do you think they will try to call him? Do you think they wouldn't call him in a million years? Do you think that they are only doing it to silence him? Let me know in the comments below. Please don't forget to hit the like button down below, and I will see you guys in the next video. Thank you so much for watching. Take care, and bye now.